I want to just start my short contribution today by congratulating Darian Fenton on the success that she's had in getting her bill out of the ballot and the effort that she went to in doing something through this bill that essentially, if this House were to pass, would represent us doing the right thing. Because the bill implements the recommendations of the Public Advisory Group to the Minister of Labour on Restructuring and Redundancy, which reported back in 2008. And so that group recommended that it was time to put in place a modest entitlement on a universal basis for qualifying employees. So I practiced in the area of employment law for many years before I came into this House, and not only is this bill a decent thing to do, it's a smart thing to do from the point of view of making the law certain. And I want to just take the House through some of the developments that the law has seen in this area to explain what I mean by that. There's never been a statutory obligation in this country to pay redundancy compensation to an employee dismissed for redundancy. And that absence of a statutory obligation at the time when we went through major unemployment in this country last, back in the 1990s, caused major disruptions in employment law. It wasn't an issue during most of the term of the last government. Interesting to hear Mr Henare's contribution on that point. There was no need to legislate for this because we had full employment. But guess what? The House needs to remember we're not in those times again. We're in times where unemployment is over 7%. And this will be an issue that the courts will have to confront again. It's timely for the House to recall what the courts did in the absence of a statutory redundancy entitlement the last time we faced high and unlikely to decrease unemployment. And I'm just going to describe some of the legal cases. First of all, sir, the courts from about the early 1980s onwards looked at what used to be called the dispute of rights provisions in the employment law or labour law that prevailed at the time. And there ended up being a number of cases over whether or not the dispute of rights provisions in the legislation could be used to confer a right on workers to redundancy compensation where their employment contract or their award or their agreement didn't expressly call for that entitlement, or if it did, didn't specify how much redundancy compensation or how much redundancy notice even they would be entitled to. And so employers tied themselves up in knots trying to work out what the law should be in any particular case where an employment instrument mentioned redundancy but didn't go further than that, didn't define an entitlement. The courts didn't give any clear guidance as to whether or not there was such an entitlement. In some cases, like the Wellington Hospital Board case in the early 1980s, they indicated that yes, there was such an entitlement. Then there was the Cornhill Insurance case, the Westland Catchment Board case, the Timbercraft case, and finally Westland again, all back in the Court of Appeal, all giving inconsistent results as to whether or not an employer had to pay redundancy. So Parliament took the matter in hand when it passed the Employment Contracts Act. Clause 34 of the Employment Contracts Bill, which became Section 46 of the Act, did away with the ability to use the disputes process to get a redundancy compensation deal. But actually the courts were a step ahead of Parliament, sir, because unemployment was still high and rising at that time. And 8 days before the introduction of the Employment Contracts Act, the Labour Court, in a decision called Wellington Caretakers Union in Hale, its second judgment in that case, following the matter being remitted to the Court of Appeal and then sent back to the Labour Court, decided that the personal grievance jurisdiction in the relevant labour law could be used to give a redundancy entitlement. And all the same problems arose, sir, for a number of years. Yes, it was deemed fair by the courts to pay compensation, but how much and in what circumstances, there was never clear guidance. Now, sir, we have the same provisions in our labour law at the moment that applied then as far as personal grievances are concerned. The test is whether or not it was fair in all the circumstances to dismiss somebody. And if the courts decide to swing the pendulum again and decide that there is an entitlement in the common law that redundancy ought to be paid to dismissed workers in certain circumstances, we'll be back in that same position. Now, no doubt this Parliament will swing in under this mean-spirited government and just abolish the entitlement. But wouldn't it be better, sir, to do the right thing, support Darian Fenton's bill and provide a modest entitlement to redundancy to workers dismissed for that reason?
Member's time has expired.